You are driving southbound on I-95 through Fairfax County. It is a Wednesday afternoon, traffic is moving well, and you are keeping pace with the cars around you. Maybe 86, maybe 87 miles per hour. Everyone seems to be going the same speed. You have driven this road hundreds of times. Then you see the Virginia State Police trooper on the shoulder. A fraction of a second later, the lights come on. Your brain immediately goes to the same place every driver's brain goes. This is a speeding ticket. Inconvenient, expensive, but still just a ticket. You pay it, move on, and complain about it at work for a week. Here is what your brain is getting wrong. In Virginia, what just happened may not be a simple traffic matter. It may be a criminal charge. Under Virginia Code Section 46.2862, driving more than 85 miles per hour or driving 20 miles per hour or more above the posted speed limit can be charged as reckless driving, a Class 1 misdemeanor. That means the officer standing at your window may not simply be writing a ticket. He may be building a criminal case, and what you say during the next few minutes can either help that case or protect you from making it stronger. Today, I'm going to explain what reckless driving in Virginia means, why I-95 and I-495 generate so many of these charges, which phrases can damage your case, and what options may exist before court. Stay until the end, because the most expensive part of this charge is often not the fine. I'm Pierre Prialé, a criminal defense attorney in Northern Virginia. For more than 15 years, I have represented drivers facing this charge in Fairfax, Arlington, Alexandria, and surrounding courts. I have seen people enter court expecting an ordinary traffic matter and leave with a criminal conviction. I have also seen charges reduced to non-criminal traffic infractions. The difference often comes down to decisions made before the court date. Sometimes it starts with what the driver says before the officer even finishes the summons. Let's begin with why Virginia is different. In many states, high-speed driving is treated as a civil traffic violation. You pay a fine, receive points, and the matter is closed administratively. Virginia made a different choice. Speed can result in reckless driving in two common ways: driving more than 85 miles per hour or at least 20 miles per hour above the posted limit. Either can be charged as a Class 1 misdemeanor, Virginia's highest misdemeanor classification. Possible penalties include up to 12 months in jail, a fine of up to $2,500, 6 demerit points, and a criminal record. That is completely different from simply paying a speeding ticket online. A reckless driving summons normally gives you a court date. That date is not an appointment to negotiate a fine at the courthouse. It is a criminal hearing. If the charge is not contested or reduced, you can leave the courtroom with a misdemeanor conviction. Many drivers do not understand that until they are standing before the judge. Now consider where these stops often happen. I-95 and I-495 are heavily traveled corridors with sustained Virginia State Police enforcement. Troopers use radar or LiDAR and document the speed, conditions, observations, and what happens during the stop. That documentation becomes part of the prosecution's case. It is also what a defense attorney reviews for weaknesses. On many sections of I-95 through Northern Virginia, the speed limit is 65 miles per hour. At that limit, driving 85 miles per hour is already 20 miles per hour over the limit, and 86 miles per hour crosses the separate threshold of more than 85. That means the distance between keeping up with traffic and facing a criminal charge can be much smaller than drivers expect. And that leads to the most common phrase people say at the roadside: "I was just going with the flow of traffic." It sounds reasonable. It feels like an explanation. But under Virginia law, the speed of the cars around you does not automatically excuse your own speed. Worse, that statement may become an admission. You are telling the officer that you knew how fast traffic was moving and made a conscious decision to maintain that speed. The same problem applies to statements such as, "I was late for work," or "I didn't realize I was going that fast." The first can suggest that you had a reason to keep speeding. The second can be interpreted as an admission that you were not monitoring your speed carefully. Most drivers say these things because they want to cooperate and show that they made an understandable mistake. But the roadside is not the place to argue your case or explain your intentions. A calm and respectful response is, "Officer, I prefer to speak with my attorney before answering questions about the driving." You should still provide your license, registration, and insurance information and follow lawful instructions, but you do not have to volunteer an explanation that may later be used against you. Now let's talk about why the consequences can be much greater than the amount written on the fine. Northern Virginia is home to thousands of federal employees, defense contractors, intelligence professionals, and security clearance holders. A criminal conviction can create reporting obligations or questions during a clearance review. The impact varies, but it should not be dismissed as just traffic. The same concern applies to licensed professionals because some boards require criminal convictions to be disclosed. For non-citizens, any criminal charge or conviction should also be reviewed carefully with qualified legal counsel because it may become relevant in immigration filings or proceedings. And for commercial drivers, a reckless driving conviction can create additional licensing and employment consequences. If you hold a CDL, the case needs immediate attention. This is why the real cost may be professional, not financial. So what does a defense actually look like? The first step is to examine the evidence used to establish speed. That can include the officer's radar or LiDAR calibration records, required certificates, maintenance documentation, and testimony about how the device was used. The next step is reviewing the stop. The officer's position, distance, surrounding traffic, vehicle identification, and notes. Not every case contains a technical defect, and an attorney should never promise that one exists. But these questions need to be asked before a driver assumes the charge cannot be challenged. The attorney must also evaluate the practical possibility of a reduction. In some cases involving a lower reckless driving speed, a clean driving record, and favorable circumstances, a reduction to improper driving or another non-criminal traffic infraction may be possible. At higher speeds or when there is a prior record, an accident, dangerous driving behavior, or other aggravating facts, the realistic options may be different. The court matters as well. Fairfax, Arlington, Alexandria, and Prince William have different procedures, judges, prosecutors, and expectations. Preparation may include a certified driving record, a driver improvement course when appropriate, and documentation that helps the court understand the driver's history. The goal is not to walk into court with excuses. The goal is to walk in with a legal and factual strategy. This is especially important for drivers from Maryland, Washington, D.C., Pennsylvania, New York, or another state. A Virginia reckless driving summons cannot be ignored because your license is from another state. Missing court can create additional problems, and a conviction may be reported to your home state. In some cases, an attorney may be able to appear without the client being personally present, but that must be evaluated and arranged in advance. Never assume you can skip the hearing. Let me give you a common example. A driver is clocked at 86 or 87 miles per hour on I-495. The driver has a clean record and assumes the court date is a formality. He appears alone, pleads guilty, pays the fine, and leaves believing the matter is finished. Months later, the conviction appears during a background check, clearance review, licensing disclosure, or insurance renewal. The problem is no longer the fine. The problem is the conviction. Could every case at that speed be reduced? No. Outcomes depend on the evidence, court, judge, prosecutor, and record. But the opportunity to pursue a reduction existed before the guilty plea. After conviction, the options are far more limited. That is the key point. A summons is not the end of the case. It is the beginning of a process. But the most useful work usually happens before the court date. Drivers often ask me, "My hearing is only 3 weeks away. Is it too late?" Usually no. There may still be time to review the charge, obtain records, and prepare a strategy. They also ask, "My speed was exactly 86. Is that really reckless driving?" Yes. More than 85 miles per hour means 86 can qualify. The fact that the speed is near the threshold may matter when evaluating possible outcomes, but it does not make the charge disappear automatically. Another common question is, "I already admitted I was speeding. Do I have no defense?" Not necessarily. A roadside statement is only one part of the evidence. The speed measurement, officer's documentation, driving record, court, and surrounding circumstances still matter. So remember these 3 things. First, if you are stopped on I-95, I-495, or anywhere else in Virginia, do not try to explain your speed. Provide the required documents, remain respectful, follow lawful instructions, and avoid volunteering statements about why you were driving that fast. Second, understand the document in your hand. A reckless driving summons is not the same as an ordinary speeding ticket. It may require a court appearance on a criminal misdemeanor charge. Third, speak with an attorney before the court date. Do not wait until after a conviction to learn what could have been done beforehand. If you received a reckless driving summons in Fairfax, Arlington, Alexandria, Prince William, or another Northern Virginia court, Right Path Law Group can review the charge, explain the possible consequences, and help you understand your options. For more than 15 years, we have represented drivers throughout Northern Virginia, including federal employees, professionals, commercial drivers, immigrants, and out-of-state motorists. The consultation is completely free and does not commit you to anything. Call us today at 703-722-8044 or visit rightpathlaw.com. Because the difference between a criminal conviction and a reduced traffic charge is not determined only by what happened on the highway. It is also determined by what you do before you walk into court.